pulling over.
Get out of the vehicle now. Step out of the vehicle. Get on your knees. Get on your knees. Put your hands on top of your head.
I'm at work.
Put your hands together, you're good, you're clapping. Go ahead and stand up. 224, 1 detained.
I'm at work.
10-4, 1 detained.
Do you have any objection to me searching you right now, ma'am?
Yes, sir.
You do?
Yeah.
Okay, do you have any identification on you?
He's in my car.
Okay, I'm Officer Dufour of the Pensacola Police Department.
Yes, sir.
The reason I'm stopping you today is because your seatbelt is off. Okay? I gave you multiple chances to stop your vehicle. All right?
Well, I was trying to get to a place that I felt comfortable.
Okay.
Yes, sir.
Okay.
Because I'm at work right now.
This is your vehicle?
Yes, sir. And I'm at work right now.
You're at work?
Yes, sir.
Okay.
I got my badge on and everything.
Okay. All right. For my safety and yours, I'm going to pat you down just to make sure you don't have any weapons on you. Okay.
That's fine. Yeah, I was just stopping, waiting until I got to a place where I felt comfortable. I'm at work right now. I'm getting ready to go see a client right now.
Who?
Me. I'm at work right now.
You're at work right now?
Yeah. I'm a counselor.
You're a counselor?
Yeah.
But do you have a client nearby or what's going on?
Yeah.
Okay. Before we ask any questions, you must understand your rights. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask any questions and to have him with you during questioning. If you cannot afford a lawyer, one will be appointed for you free of charge before any questioning if you wish. If you decide to answer questions now without a lawyer present, you'll still have the right to stop answering at any time until you talk to a lawyer. You understand your rights.
Although Miranda rights do not play a major role in this interaction, this is a prime opportunity to discuss this highly requested topic. For many years, the Fifth Amendment's self-incrimination clause was traditionally understood only to protect Americans against formal types of compulsion to confess, such as threats of contempt of court. However, in the 1966 Supreme Court case of Miranda versus Arizona, the court established a new precedent regarding the Fifth Amendment's protections. In the case, the court held that a prosecutor may not use statements made in response to interrogation in police custody as evidence at their trial, unless they can show that the person was informed of the right to consult with an attorney before and during questioning, and of the right against self-incrimination before police questioning, and that the defendant not only understood these rights, but voluntarily waived them. This ruling led to what is now known as Miranda rights, which refers to the formal warning that officers must issue to suspects in police custody before they are interrogated or questioned. Contrary to popular belief, a citizen may be detained or arrested without having been read the Miranda warning, and the warning only applies when an officer questions a suspect about a particular offense or suspected criminal activity. In the 1984 Supreme Court case of Berkemer versus McCarty, the court expanded the Miranda ruling to include protections for anyone in police custody, as it had previously only been applied to serious offenses. And in the 2010 Supreme Court case of Berg-Hewis versus Tompkins, the court added the stipulation that citizens must actually state that they wish to invoke their right to remain silent, or else their subsequent voluntary statements may be used in court and police may continue to question them. The court clarified that the mere act of remaining silent is insufficient to imply the suspect has invoked their rights, and citizens must verbalize the notion that they are invoking their right to remain silent. This ruling is particularly relevant to interrogation scenarios, as one must state that they no longer wish to speak with officers in accordance with their Fifth Amendment protections, or police may continue to interrogate them. Invoking your Fifth Amendment right to remain silent is a powerful tool in any police interaction. However, it is not a solution for every possible circumstance surrounding police encounters. Mr. Black voluntarily waived his right to remain silent and chose to engage with Officer Dufour to defend his actions. Mr. Black's choice to speak with Officer Dufour may serve him well in the courtroom, as it offers the court a legitimate explanation for his decision to not immediately pull over, and absolves the court from drawing its own conclusions about Mr. Black's intentions.
So you cool with talking to me?
Yeah.
Okay. So you have no ID on you right now?
Yeah, it's in my car.
It's in your car? Okay. Do you have
I got my work ID on me.
Do you have any objection to me searching your vehicle right now?
Oh yeah.
You did?
Yeah.
Why?
Because for one, there's no smell of marijuana or
That's
alcohol.
I'd
Number
never
two.
mentioned any drugs.
Right.
Or
And
anything
number
like
two,
that.
I think, the stop is based on, I don't even know why you stopping me right now.
I explained my stop to you. Okay.
So, yeah. I mean, I object to the search. I mean, I'm at work. I was leaving Walgreens and I'm headed to see a client do a session. I'm a
Okay.
counselor.
Why did you flee from me?
I didn't flee.
You never stopped.
I was
You
waiting
never
until I
stopped.
got to a place where I felt comfortable.
You never stopped.
So that's the only thing that I'm saying. I didn't flee. I'm literally at work right now. Like I
You
got
could
my
have
work
stopped
on.
at any moment.
I got my work badge on me and everything.
The language of Florida's fleeing or eluding statute is relatively stringent and often difficult to defend against, with few exceptions. Florida Statute 316.1935 states that it is unlawful for the operator of any vehicle, having knowledge that he or she has been ordered to stop such vehicle by a duly authorized law enforcement officer, willfully to refuse or fail to stop the vehicle in compliance with such order, or having stopped in knowing compliance with such order willfully to flee in an attempt to elude the officer. Subsection 2 of the code states that any person who willfully flees or attempts to elude a law enforcement officer in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle with siren and lights activated commits a felony of the third degree. The wording of Code 316.1935 implies that citizens must stop immediately upon an officer's signal, and Florida's 4th District Court of Appeals affirmed this notion in the 2013 case of State versus Cryer. In the case, the court held that although the officers chasing Mr. Cryer were attempting to effectuate an illegal arrest, and Mr. Cryer did not increase his speed or break any traffic laws during the 5-minute pursuit, he was still guilty of fleeing from an officer under the language of Code 316.1935. This ruling essentially solidifies the notion that citizens in Florida must pull over the moment an officer turns on their lights or siren. All that said, there are a few legitimate defenses available to citizens who are charged under Florida's fleeing or eluding statute. For example, Code 316.1935 specifies that pursuing police vehicles must be marked with agency insignia and other jurisdictional markings prominently displayed on the vehicle, and Florida courts have dismissed cases where undercover vehicles were the primary vehicle of the pursuit. Certain emergency situations may also offer a defense to not stopping for an officer, such as being in labor or any other dire need for medical attention. However, they must be thoroughly proven in order to be successful. In an interview with the Pensacola News Journal, Mr. Black states that the reason he did not immediately stop was because he didn't want his client to witness his interaction with the officers, and said, quote, "It's not good for anyone to see their counselor get pulled over by the police." Whether or not this would be considered a legitimate defense to a court is debatable, but courts are charged with the duty of examining the totality of circumstances surrounding any police interaction, and it is possible that a court would consider Mr. Black's assertions valid.
I'm legit at work right now. Yeah.
That gives you no excuse to stop when I'm trying to pull you over. Not stop.
What I was saying is, I wasn't fleeing. I was just waiting till I got
That's
to
fleeing
a
from
point.
law enforcement.
I did not increase
That is
my
fleeing
speed.
from law enforcement.
I did not increase my speed, officer.
That does
Okay.
not matter.
The only thing that I'm saying is this: I was not fleeing. I'm literally at work. I left
The moment that I
Walgreens.
initiated my lights and sirens and told you to stop, you're required to stop for law
The
enforcement.
only thing I'm saying, officer,
Okay.
is this: I did not flee. I was waiting till I got to a point where I felt comfortable to stop. Literally have no.
I need your license, your registration, and your insurance. So I have permission to enter your vehicle and grab those items.
Can I get it?
No, sir. You're detained right now. You fled from law enforcement.
I didn't. I'm literally at
You
work.
fled from law enforcement.
And
I'm
I-
not going to argue with you about that anymore.
Can you grab your license, registration, and proof of insurance?
Yes, sir. Yes,
Where
ma'am.
is it at?
I got it in my front seat.
Just in your front seat?
No, I got my license in my wallet, and
Okay.
then I got my. The rest of it is in my glove department.
Okay.
I can grab it.
Can he go grab it? Can I go grab it?
No, ma'am.
Mr. Black is well within his rights to deny consent to search his vehicle in the absence of probable cause. I have covered the topic of search and seizure in many of my other videos, and I will not spend too much time on it in this episode. However, this does not fully remove the search powers of an officer. After Mr. Black denied the officer's consent to search his vehicle, Officer Dufour returns to his patrol car and makes a call to Sergeant Brierton for consultation on whether a fleeing charge was applicable and whether or not he could conduct a search of Mr. Black's vehicle. The sergeant advises Officer Officer Dufour not to charge Mr. Black with fleeing and authorizes Officer Dufour to conduct a search of Mr. Black's person and the immediate area of where he was sitting. Under the Terry Doctrine, if an officer possesses a reasonable belief based on specific and articulable facts that the suspect is dangerous and may gain immediate control of weapons, then the officer may conduct a brief pat-down of the individual and the area in their immediate reach. The Terry case specifically states that officers must have a reasonable belief that the suspect is dangerous, and it is difficult to understand what facts would lead Officer Dufour to believing that Mr. Black posed a threat to the officers.
Stay seated.
Okay.
After releasing Mr. Black from the handcuffs and issuing him a citation for not wearing a seatbelt, the Pensacola officers allowed him to go free without further incident. Several months later, Mr. Black obtained legal representation and filed a lawsuit against the department, claiming damages of $200,000 for emotional distress and severe physical, mental, and emotional harm. Mr. Black's attorney, Alistair McKenzie, told the Pensacola News Journal that Mr. Black was treated unjustly because of his race and the older model car he was driving. Mr. Black is due in court on October 16th for the seatbelt citation, but maintains his innocence and plans to dispute the charge. The Pensacola Police Department has publicly stated that it cannot comment on the case, citing the pending lawsuit. Overall, Officer Dufour gets a B, because although he conducted a questionable search of Mr. Black's vehicle, much of his conduct was within the bounds of his authority, and he made an appropriate decision to call a supervisory officer for further consultation, rather than taking the risk of making a mistake. It is difficult to penalize Officer Dufour for following the letter of the law, and much of the questionable conduct of this interaction is due to the actions of the legislative and judicial branches of Florida's government. This encounter highlights a clear disconnect between the enforceability of the law and its interest in preserving the safety and logical practicality of its constituents. Mr. Black's reasoning for why he did not instantly pull over seems reasonable, but it clashes with the language of Florida's fleeing statute, and courts routinely interpret the law precisely as it was written, rather than questioning its functionality and the implications associated with it. Laws are meant to be executed in service of the greater good of society, but the nature of the American justice system often creates an environment that is conducive to abuse and semantically justified wrongdoings. Officer Dufour's conduct alludes to grander issues facing American citizens, and as mentioned earlier, it is difficult to fault him for doing what high courts have justified in the past. Mr. Black gets an A, because although his actions may or may not have violated Code 316.1935, he maintained a calm and collected demeanor throughout the interaction, legitimately refused to allow the officers to search his vehicle, and followed up this encounter with the proper legal action. Mr. Black's decision to waive his right to remain silent served him well during this encounter, and although the right to remain silent can be a powerful tool during police interactions, Mr. Black's encounter highlights the importance of invoking that right reasonably and responsibly. Mr. Black also navigated this encounter with a respectable degree of patience and awareness, and balanced the officer's request for an explanation with maintaining his constitutional rights. I commend Mr. Black for remaining vigilant about his rights while also ensuring that he dispelled Officer Dufour's suspicions about his behavior, and I hope Mr. Black's actions can serve as an example for all citizens who interact with police in the future. Let us know if there is an interaction or legal topic you would like us to cover in the comments below. Thank you for watching, and don't forget to like and subscribe